Hello everyone, this is Dr.P.Syamala from the Department of MBA International Business, Acharya Nagarjuna University. And this is the part 3 of Sebi Act, as we have discussed in previous two parts about the introduction and about the powers, about the functions, about the penalties and offences. Okay, and now we are going to study about the cease and desist order and the remaining aspects. Okay, so if we see about section 11D about the cease and desist order, what does this means? Okay, cease means ending and desist means to stop. Okay, so this section 11D deals with the cease and desist powers of the SEBI. If SEBI finds, after causing an inquiry to be made, that any person has violated or likely to violate any provisions of this act, means any rules or regulations made thereunder, it may pass an order requiring such person to cease and desist from committing or causing such violation. Okay, so it can stop, SEBI can stop any person from violating the rules and regulations of the SEBI. Okay, and if we see, cease and desist order can be passed only if reason to believe that company indulged in insider trading or market manipulation. In these cases only it can cease, or else it can desist the company. Now coming to section 12, registration of stock brokers, sub brokers, etc. All intermediaries who participate in stock markets should register with SEBI. Okay, then manner of application as determined in regulations. They have to apply for the SEBI, these intermediaries. Okay, in the manner according to the SEBI. Okay, according to the manner of SEBI, they have to apply and register. Okay, then 12A, a prohibition on certain activities. Okay, so what are those prohibition on those persons? Okay, on those actions, no activities. No person shall manipulate, deceptive device dealing with the stock market. Okay, no person should do manipulations, engage in insider trading. Those intermediaries, they shouldn't involve in the insider trading. Also defraud in connection with issue of securities. Any defraud they shouldn't do. Likewise, substantial acquisition of shares or control. They shouldn't possess substantial acquisition of shares, okay, or control on the company. Okay, so these are the prohibited activities by these intermediaries. Then section 14, SEBI fund. Okay, so we all know that we have credits and debits. So under credit account, what we can see means grants, fees, charges, such other sums as prescribed in the SEBI, okay, by the central government. So all these amounts are credited in the SEBI fund. Okay, so grants from central government, fees collected by the SEBI, fees or charges, grants, all these are credited in the SEBI fund. And if we see in the debit account, what debit account shows means it pays salaries, SEBI pays salaries, allowances of members, employees of board, etc., and expenses of board in discharge of its functions. In order to perform the functions in the SEBI, it has to make some expenses. Okay, so all this can be taken from the SEBI fund only. Now section 15 means prepare annual financial statements audited by the CA or AG, okay, and forward audit report and audit accounts to central government. So section 15 deals with, okay, SEBI must conduct annual financial statements which should be audited by the CA or AG, forwarded to the audit report and accounts to central government. These audited financial statements should be produced to the central government. Now coming to 15A to 15HP regarding the penalties, as we have studied in part 2, we have completed thereover. Now 15J, what does this say? Factors to be taken into account while adjudging quantum of penalty. So what factors should we consider, okay, while applying or else while going for penalty? Okay, so if we see amount of disproportionate gain or unfair advantage, whether that person gained Okay, what proportion of amount, what proportion of gain, any unfair advantage, so that is to be considered. Then amount of loss caused to investor, okay, by that particular offense, by that particular unfair advantage, what is the amount that is lost by the investor. Then repetitive nature of default. So if at all that particular investor, particular intermediary do the same thing repetitively, means, so all these factors should be considered while levying the penalty. Then section 15J, penalties realized shall be credited to Consolidated Fund of India, not to Sebi account. Okay, so penalties have been collected and those penalties will be realized in where we will see those account, means in Consolidated Fund of India, but not in Sebi account. Okay, we have to this is an important thing that we have to remind. Okay, then 15JB is about the administrative and civil proceedings can be settled with the SEBI. So if at all there are any disturbances, any acts, any settlements were there, means all those will be settled with the SEBI only. But this settlement order is not appealable. As I said before, once a settlement has been done in SEBI, means it cannot appealed. So settlement amount to be credited to the Consolidated Fund of India. Now we have to study about Securities Appellate Board or a Securities Appellate Tribunal, which is known as SAT. Okay, so this SAT consists of presiding officer, judicial member and technical member. So if we want to say about the SAT, okay, about SAT means SAT consists of 3 members, okay, 3 persons, presiding officer, judicial member and technical member. Okay, so the central government specify in the notification about the matters and places in relation to which Securities Appellate Tribunal may exercise its jurisdiction. Okay, so composition of Securities Appellate consists of the PO, presiding officer, judicial officer, technical member. Presiding officer is the head of the SAT and judicial members and technical members are the members of the SAT prescribed by the central government. Okay, means appointed by the central government. So if we see these members, presiding officer and judicial members, are appointed by central government by consulting the CJ, which is nothing but Chief Justice of India or his nominee. If we see about technical member, okay, so technical member is nothing but secretary in ministry or department of central government or state government. If we see judicial officer, he is the judge of high court for at least 5 years. Okay, if we see presiding officer, he is the judge of Supreme Court or Chief Justice of High Court for at least 7 years. Okay, so and if we see about the technical member, person having professional experience of not less than 15 years in financial sector including securities market. This is the qualification regarding the technical member. And technical member is not appointed by the central these are directly appointed by the central government, and here recommendations through central government recommendations of search committee and selection committee, technical member will be appointed. So who are those search committees and selection committees? Okay, means preceding officer, okay, secretary Department of Economic Affairs, secretary Department of Financial Services, legislative department, Department of Legal Affairs. So all these are the committee members, okay, search and selection committee members who will appoint the technical members will be appointed by the search committees and selection committees. Okay, and see this Securities Appellate Tribunal, the principal bench will be in Mumbai, and benches across India will be in every state. Okay, this SAT will be there, but the principal bench will be in Mumbai. Okay, so every bench will have one presiding officer and with at least one judicial member and one technical member will be there. Okay, and here we have to note one thing: presiding officer of SAT may transfer any judicial member or technical member from one bench to another bench. Okay, so if we see See, composition of Securities Appellate Tribunal. Central government establishes SAT, and under SAT, presiding officer, judicial member, and the technical member will be there. Okay, presiding officer will be the head of the SAT. Members are prescribed by the central government. Okay, so if we see the qualifications, as I said before, Chief Justice will be the High Court. In presiding officer case, in judicial member case, Judge of High Court will be there with having at least 5 years, and here at least 7 years will be the experience. And technical member, if we see, means about technical member, he will be secretary or additional secretary in the Ministry of Department of Central Government or any equivalent post in central government or state government. And at the same time, he is a person or proven ability, integrity and standing, having special knowledge and professional experience of not less than 15 years should be there. Okay, so a secretary or an additional secretary in the Ministry of Department of Central Government. And validity for appointment means SAT not to be challenged on grounds of defective search cum selection committee. Okay, here if we see the validity point, okay, so under validity point, these members of the Securities Appellate Tribunal shall be invalid merely by reason of any vacancy or any defect in the constitution of the search cum selection committee. Okay, and if we see here Sebi members or IRDA members or any PFRDA members, so this during his service or tenure or within 2 years of cessation of service, appointment will be not made by these members. Okay, so a member or part-time a member of Sebi or Insurance Regulatory and Development Authority, IRDA means, okay, and Pension Fund Regulatory and Development Authority or any person at senior management level equivalent to the executive director in the Sebi or in such authority shall not be appointed as presiding officer. Okay, so these members shall not be appointed as presiding officers. Okay, as presiding officers, as JMs, that is nothing but judicial members and technical members. Okay, so the presiding officer or such as a member of the Securities Appellate Tribunal holding office on the date of commencement of the Act, okay, shall continue to hold office for such term as he was appointed, and the other provisions of the Act shall apply to the presiding officer. Okay, then appeal to the Securities Appellate Tribunal. Okay, so if we see SAT shall dispose of appeal within 6 months. If at all there are any appeals, then SAT will disposes them within 6 months. It will clear those appeals within 6 months. Any person aggrieved by an order of Sebi made or by an order made an adjudicating officer under this Act or by an order of IRDA or PFRDA may prefer an appeal to a SAT having jurisdiction in the matter, okay, within a period of 45 days from the date on which a copy of order made by the Sebi or adjudicating officer of the IRDA or PFRDA, as the case may be, is received by him, and it shall be in such form and be accompanied by such fee as prescribed. As I said before, within 6 months. Here if you see, from this to this, within 45 days they have to take, okay, the adjudicating officer with a copy order made by Sebi adjudicating officer, okay, is received by him, and it shall be in such form and be accompanied by such fees. Fees also should be paid. On receipt of appeal and after giving the parties to opportunity of being heard, SAT pass order as think fit, confirming, modifying or setting aside the order appealed against. So when it receives the appeal, as the parties will pay the amount, okay, then only it will give its or else it disposes the case. Okay, so it depends upon the order. It passes the order depends upon the fitting of the case, confirming of the case, modifying or setting aside. Okay, then the Securities Appellate Tribunal may entertain an appeal for after the expiry of the said period of 45 days if it is satisfied that there was sufficient cause for not filling it within that period. Okay, so any appeal, it can the SAT may entertain any person any appeal regarding this after the expiry of the said period of 45 days here. Okay, so even though this period is over, okay, but it allows other persons, okay, to for appeal, okay. So for sufficient cause, if at all it is a sufficient cause, it can allow the persons for filing of for appealing, okay. Then so here it is about appeal to SAT, okay. As I discussed now about the things about SAT, means persons aggrieved by order, adjudicating authority, insurance regulatory and development authority, pension fund regulatory, all this comes under the SAT only, okay. So the time period is 45 days from date of order. SAT can done, means it can dispose. Then appeal shall be disposed by the SAT within 6 months. SAT has all powers of civil court under Code of Civil, okay. SAT operates through constitution of benches only. So okay, here if we see that in various locations, and it appoints technical judicial members, each of those benches and cases will be trialed, okay. So as I said before, head office will be at Mumbai, and in each state we will have a SAT, and in each state we will have a presiding officer and judicial member. They will see the cases, okay. Trials will be done by them, and if at all there is any difference of opinions between the benches, okay, then it will refer to the preceding officers, okay. So if at all there is this difference of opinion between the judicial member and the technical member, or else between the benches, then this case will be moved to the PO, preceding officer, okay. So this preceding officer may forward that to any person aggrieved by the order of SAT and make appeal to Supreme Court, then okay, within 60 days. Then decision will be taken by the majority of members. 2 members of difference of opinion will be considered. Then this presiding officer will go to Supreme Court, and Supreme Court grant extension of period to another 60 days, and they will dispose the case. And central government to suspend the board, okay. So suspending of board is nothing but take over the powers of board, okay. So superseding by the central government, so it takes over the powers of the board. Why it takes over the board power means, whenever the board is unable to discharge the functions and duties, and in case of default to comply with the directions issued by the board, in such cases central government supersede the board, means take over the powers of the board. Then what is the effect of supersession? All members shall vacate the office, okay. Then all powers of the board were exercised by such person appointed by central government. So whenever all members are vacated, okay, then there should be a person to do the activity. So that person will be appointed by the central government, and all property of board shall vest with the central government only. So after period of supersession, central government shall reconstitute the board. Again it has to reconstitute the board. So the vacated member can also be reappointed. Again that for example, if any person, the vacated person is there, if he is capable, means that person will be again reappointed whenever the board is reconstituted, okay, after supersession. If we see about section 18, board shall within 90 days from end of financial year submit a report of all its activities to central government. So members, officers, employees of board and preceding officers, members of SAT shall be public servants. So members, section 18 says that board shall within 90 days from end of financial year submit the report, okay, what are the activities to central government. Then what about 24A, criminal offences which are punishable? So with imprisonment only, or with imprisonment with fine, okay. And they can be compounded also. Compounded is nothing but in place of imprisonment they can pay fine. Likewise it is known as compounded, okay. So special courts for criminal offences, okay, we have special courts for criminal offences. So single judge appointed by the central government in consultation with Chief Justice of High Court. For these criminal offences, a single judge will be appointed by the central government, okay, in consulting the Chief Justice of High Court, okay. Then what are the qualifications? Means immediately before appointing the holding office as sessions judge or additional sessions judge, the qualification is he should be the sessions judge or else additional sessions judge. Then particular area has more than special court, okay. Special court as specified by High Court with trial and code of criminal procedure applicable for proceeding before special court. Okay, means here particular for this criminal offences, if in particular area there are two courts, means then in which court will trial the offence, this is seen here. That is known as particular area has more than or special court. In such cases, how to see? Okay, then special court as specified by the high court will trial the offence. So high court will trial the offence. Then what is the note? Means note is about the code of criminal procedure applicable for proceeding before special court, and appeal against special court is in high court. Okay, so appeal against special court, this is done in the high court. Okay, so this is about the Sebi.